let's get started with that. The start of event number 1, do you have that available?
Yes. As in, do you want me to show it by video?
Yes.
Okay.
So just so everybody's clear that this is to just establish literally the time frame, the seconds, fraction of a seconds, within which things were done, to counter Binger's characterization of what happened.
So at this point, and understanding what this point is, this is from, if you can see on your screen, the parent file. This would be the point where friendly, friendly, friendly is heard within the soundtrack. And obviously we can play that as well. So
Please.
Your Honor, I'm going to object. This is beyond the scope of the court's order.
Get out of here, Binger. Get out of
Has he
here.
been recognized as an expert yet?
And
The voir dire is over?
No.
This is all timing.
Almost 5-minute breaks on the library.
Yeah, this seems like timing.
Let's do that. Please hold on one case.
It's vital for the jury to appreciate just how fast this happened and how quickly Kyle had to make these decisions so they can determine the reasonableness of his response to the attacks he was facing.
And I'm seeing a lot of people saying Z's in the chat boring, but this is expert. Qualifying an expert is never sexy. It's never fun. It's never going to be riveting. It's always going to be, paint drying, but you got to get it done.
The expert's also very good at answering the questions in a way that is helpful in terms of padding the question, because he knows like how to tweak the question basically in his own head because he's done so much.
Do you guys think it was prejudicial for the judge to recognize him
I was
pretty much as
totally
the only
thinking-
person on Veterans Day
I was totally
while
thinking that.
he was in the room?
Yep.
Yeah,
I thought
and
that too.
Well,
that may just be his
Court is signed an order.
MO for
let's
Veterans
applaud the
generally,
guy
but
that
the
testified
timing.
for the defense.
Hold on.
That order indicates that he is going to be allowed to testify to what is contained on paragraph 19 of his preliminary report dated July 31st, 2021, in subsection 3A1. That subsection reads,
This is a report, counsel.
page 19, subsection 3A1. This pertains to the shots at Joseph Rosenbaum. That subsection reads, the 4 shots occur in approximately 1 second with the times in hundredths of a second of 0.26, 0.25, and 0.23 respectively between shots 1, 2, 3, and 4. The court has also ruled that the witness can testify as to the information contained on page 22 of his report in paragraph 4A and 4A1. That pertains to the timing of the shots in what counsel describes as the second event, where the defendant shoots at the unidentified individual, Mr. Huber and Mr. Grosskreutz. And there's some timing information there. I won't read it right now because it's a little bit longer. But the court's order is very specific, that those are the items he can testify about with regard to timing. There's another section of his report he can testify about that has to do with sense making, but
Pretty sure you
right now,
Opened
he's
the
being asked
door
about timing. And we
on
have
all
a
of the video.
document, which I guess is exhibit number 142, that was just presented to us this morning. It appears to have all of them, except for like 4 or 5 of them, are beyond the scope of the court's order. This document contains characterizations of behavior that this witness is not allowed to testify about.
I haven't seen the document.
Okay, so for example, he indicates with observation number 7.
Is there a copy? Go ahead, Mr. Lee.
Observation number 7 is characterized by this witness as JR elevation change hyphen lunge decision point. What I'm interpreting that is Joseph Rosenbaum's elevation change lunge decision point. This witness is not, by the court's order, allowed to testify as to what Mr. Rosenbaum was doing or his intent or anything like that. This was the subject of our motion hearing. The court has excluded that. There's other characterizations too. For example, the reference observation point number 15 and 16, referring to people striking the defendant. Number 19, striking the defendant. Number 22.
I don't think that's a characterization.
Number 25.
Notice how Binger is calling out titles.
Pointed towards the defendant.
And now he intentionally
These
titled
are
that
all
his
things
video is
that
militia.
The preliminary report that this witness offered talked about, but now we
So
have
thoroughly
ruled,
duplicitous.
we've agreed, and the court has ordered that he's not going to be talking about those things. So the scope of this document 142 is well beyond the court's order. What he's being asked right now, and when I objected, is beyond the court's order. What he is characterizing in this exhibit 142 in terms of his interpretation of what various people in the case were doing or what their intent was or anything like that is beyond the scope of the court's order. So my understanding from the court's order was he'd be able to say gunshot 1, 2, 3, and 4 to Rosenbaum happened in this amount of time. And then the second set of gunshots happened in this amount of time.
That's what he's doing.
That's it.
Just time
That's where
framing
it's
it.
timing. The court's order was very specific. as to
Overruled.
that. So when we're talking about friendly,
And again, Binger's introduced so much video and
throwing the
evidence.
bag or things like that.
Without any foundation on much of it, and mischaracterizing, and with hearsay.
Wait,
He reached
here.
times. And it's all evidence that's already been testified to and admitted. Some of the evidence has been enhanced, just like the state enhanced the bag, some of the other photos. He's a licensed, trained video
Expert.
specialist. He has the background, and we're showing the jury what he used to get these values. And that shows how he did it and the reliability of doing it. And I'm not worried about what Mr. Binger's talking about, the comments or anything like that. That's a way that he found the times. Your Honor, just time in relationship to video in this case is so important. Yesterday afternoon, Mr. Binger spent much time cross-examining my client regarding those approximately 30 frames from the BG on the scene. And that was approximately a 1/10 of a second. And he spread it out. And what we're trying to do is show through video the true events of that night. And I believe it is with the court's order, because basically what we're looking at is an event, and the state can quibble with my time of when I started the event. They might say it's back 5-10 seconds before or whatever, but the total time of the event from friendly until he surrenders at the police car, 2 minutes and 55 seconds. The jury should know that. The events,
Right.
each of the sub-events, the total time.
Look at Binger's face.
What happened?
Yeah, obviously Binger doesn't want that level of
The jury should
clarity.
know that.
He
They've
wants
been shown
confusion so
videos
people
already.
conflate that time period.
Well,
Now the public knows.
If I may respond.
Yes, sir.
First of all,
Stand
what
up, Binger.
Council's just mentioned in terms of the overall timing is something he's free to play video and argue. The question is what this expert witness can testify to. The court has
Timing.
ordered specifically what he can and cannot testify to. Your order is one of limitation. It specifies the limits of what he can testify to. It's a fundamental notice issue, Your Honor. In his preliminary report, he didn't have information regarding the timing from friendly. That was a report from
What
3 months
chutzpah.
ago. We
Yesterday, he was
found
arguing that the
there
courts
would be
Open the door.
The court's order
as to the timing
wasn't
of
really
the very beginning
Pinch
of all
and
that
this.
zoom.
clear, and that his interpretation of it
This Exhibit 142 is the first
was
document.
that it was
We
still
received-
you know, a
received today.
loosey-goosey situation.
Provided yesterday.
Don't interrupt. Don't interrupt.
It is the first document we've received from the defense pertaining to this witness with regard to the timing of the entire evening. It is beyond the court's order. We have not received proper notice as to this subject. I have no problem having this witness testify to observations 8, 9, 10, and 11. That is the exact scope of the court's order. Shot 1, shot 2, shot 3, shot 4. I have no problem with him testifying as to items, observations 20, 21, 23, and 26. Those are the 4 shots in the second incident with Grosskreutz, Huber, and the unknown assailant. That's exactly what this court limited him to. Those 8 observations on this sheet of paper. Everything else on this exhibit, which we just received, is beyond the scope of the court's order. We've not
Fifth
been
time I
provided
said it.
notice of it. It wasn't
time
in his
said it.
original preliminary report. It is being sprung on us in the middle of trial. The court has ordered on this. We had a hearing on this. The court gave the defense opportunity to put us on notice of these things. We talked about these limitations. There was an agreement among the parties as to these limitations, which led to your order, Your Honor. And now the defense is going around that order. And I object to that.
Your Honor,
Judge is not going to
I
have
ask the
this.
court to think back to what's happened procedurally in this case. That FBI video didn't come around until about 2 weeks before trial. The drone video didn't come back until
Jury.
Friday.
during
Friday.
trial. And most of this work has been done over the last 2 days to catch up to those exhibits. I provided
There you go.
this exhibit yesterday afternoon when it was first provided. The only change to it is and was a typo, which actually inures to the state's benefit by adding approximately 9 seconds.
What would Binger care
I quibble
to
with
establish
counsel.
the duration
The
of time?
FBI video was.
Oh, he
made
cares because he
available to
doesn't want
counsel
that
over 3 months
specificity.
ago.
The judge is going to know
That
that.
is
I don't want to, you know what? I don't want to get into it. I don't want to get into it. It's been argued about before, and then we laid it aside. And at this point, I don't think I want to get into that because it isn't going to be
He's
helpful
denying
to resolution of the issues that we're after in the case. And I'm looking for the order. What was the date of that order?
He's denying it.
I think so. Wait,
November
overruling the
2nd,
objection, you're saying, or
public
sustaining the objection?
He's sustaining the objection. Binger's winning this one.
I believe that order was drafted by
I'm
Mr.
calling
Binger.
overrule.
It was.
And
I
I-
submitted it to all parties. There was no objection to it. It was signed with no objection.
You want to make a bet?
Um,
Next video? Next video? You can do a shout out to Good Logic on your next little standalone video.
I am, here it is.
If I
That's
lose,
in the
I'll shout out
chat.
to you.
Maintain, M for maintain.
All right, I say the order without objection and without really giving it a lot of scrutiny. As you know, we try a lot of cases in here, and because it came in without objection, I signed it, thinking that it covered what I had envisioned at the time of the hearing. I will tell you what I had in mind when I haven't looked at if there is even a transcript in existence. I don't think so, but it certainly was my impression that we were talking about video of the entire episode.
Mhm.
And not that it certainly in my mind was not limited to
4 gunshots.
Good job, Viva.
Oh man, I feel like Joseph Rosenbaum right now.
Specific numbers,
Giant W.
observation point list that you're talking about. I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making?
It's Binger face. He called that Binger face.
Your Honor, yesterday I was the target of your ire.
Oh,
He's a victim.
God.
Well, here we go.
Today, the defense is disregarding your order. I
The world's
submitted
smallest
that draft
violin
of
that
that
my heart
order
weeps for you.
to the defense. They had an opportunity
This
to
is
review it. They had an opportunity to object to it.
egregious
We do this
manipulation.
all the time in the court system. We submit proposed orders to the defense, to the other side, and to the court for everyone to take a look at. If anyone
Binger
had
face.
a change, an objection to that, if they
Oh
wanted
God,
to
how on earth
expand
would
it,
Binger as a
there was
judge?
plenty of opportunity.
Can you
to do
imagine?
so. There was no response whatsoever from the defense. They never came to this court and said, the proposed order is.
We tried to win by
Here
trickery.
is our version of the
They
order.
only got some of
They
the
never
video
came to the court and
3
said
days
the
ago.
Proposed order needs to be amended in some way. They never responded at all, even though they had it, and even though they had plenty of opportunity to do so.
I don't believe you.
They have every incentive to make sure that the court's order with regard to their expert witness is accurate. They have every incentive to make sure that that court order gives them the opportunity to get in all of the evidence through this expert.
Shouldn't have let
that
Binger
they
write the
feel
proposed
they need
order,
to
by
get
the
in.
way.
Despite having that very
Yep.
powerful incentive, they did not object. They did not contact the court or me with any reaction to that order. You are the referee. The
Yep,
parties
he's the
argue about
referee.
things and you make a decision. We reached an agreement on this at the Daubert hearing.
I don't think it
Agreed.
was.
Oh, kind of like the one that you just
I
Not
dismissed
this up
yesterday.
last night. I did,
Ignored?
because there was some
Let's see which
back and
one.
forth about the extent of
Binger
use
cannot
force
read a room.
issues and all that stuff. And I said, well, what about if we just
He's,
agree?
it's narcissism.
Dr. Black can talk about the timing of the
Yeah.
shots and
But I
the
lost this
sentencing.
bet. I'm gonna
I then
mention you in my
drafted
next
this
video.
order.
The main question of
You
justice,
gave
what
the defense
difference does it
an
make
opportunity to
if
object.
Binger
They
allows
didn't.
this?
You signed it.
Okay, Hillary.
And my recollection, and again, I know you referenced the
painting a
transcript,
narrative.
but in his preliminary report, Your Honor, all he talks about is the timing of the shots. In event 1, the 4 shots of Rosenbaum. In event 2, the shots of against the unknown assailant Bieber. So
Yeah, you're right.
there's nothing further in his preliminary report about the extent of this entire time frame. This exhibit 142 goes well beyond his preliminary report from July 31st.
Your order. He's
It
gonna
goes
talk about his
well
order.
beyond what we talked about at the Daubert hearing. It
Your
goes
order.
well beyond what we agreed to that day, and it goes well beyond this court's order.
Does it go well beyond?
No, it doesn't.
I don't
If
believe
I
you.
understand correctly, what's being pursued by the state at this point is timing sequence for the time between the friendly and the surrender to the police, which he says is a
Yep.
total of 400 and some, or attempted surrender to the police, which he says is a total of 4 minutes and some seconds. All
2
of which
minutes.
is, every
55
second of
seconds.
which I think has been analyzed here in this courtroom.
Yep.
Yep.
By
That
you.
was certainly my vision at the time we discussed all this, whether it was, each part was specifically discussed in his preliminary report or not. That was my vision of what we were going to be hearing. And I guess the questions I have is, what is the prejudice to the state?
Thank you.
Are you suggesting that what he's about
That's
to
a legal bias
testify
question.
to,
Is going to mislead the
or may
jury.
testify to,
And Viva question.
Is-
I misled the jury by
going to
showing
be
them the
different
facts.
with respect to the new periods of time than it is with respect to the particular periods that you identified in the order that you drafted?
Your Honor, I carefully tried to
Or,
manipulate the
that's number
jury.
one, as to whether there's
That's why it's
prejudice to the
prejudicial.
state.
It's devastating to my case.
Secondly, whether you think that there is some incongruity between.
I would have thought that the late
periods of time
introductions
that
by the
might
state
be more-
would give grounds
more
to say, look,
fully,
this rule's been
covered
ignored
by
before to
the
help you. So
examination
this
of
order
the
was
entire
ignored
time period.
when you had late submissions.
Because those are the principal issues. We're here, and you've practiced here.
Pursuit
You
of
were assigned here
justice
for
is
quite
what
a
you're
long
there
time, some years ago. And
It's supposed to be.
I think that most people would say that I'm pretty open to, I want to have the whole thing presented to whomever is finding the facts, whether it's me or whether it's the jury. I want to know as much as possible rather than try to isolate particular things and say, well, that isn't. I told the story the other day about the judge from Madison who was tormented whether to grant a
Look at Binger's
Oh,
face.
motion
Binger
to
just
dismiss
really
a
wants to hear stories
murder
now.
case on,
That
He has
makes-
resting to your face.
That'll
not
soothe
just
the wound.
venue, whether that municipality was in Dane County or not. And I think, really, are you really worried about this? I don't operate that way. Now, I'm not criticizing you for bringing up this issue. I think it's legitimate, but it's not something that sways my judgment in the case. And unless you can tell me that you have reason to believe that doctor is going to testify differently about some of these other time
Basically,
periods
it's like,
within
I'm
that
not mad.
less than 5 minute
You're
period,
just wrong.
or that you are somehow prejudiced
Yeah.
prejudiced by the late arrival of the report, and I don't want to say late, although okay, that's fair. Then I'm going to allow the testimony to be given.
And by the way, Nick is 100% right. Never let a sneaky lawyer draft anything because they will always know
Yesterday-
what they intended to screw you out of when they drafted it.
I was
Of course.
the court's ire.
No, I don't want to talk about.
Well,
Why don't we
I think
just-
it's a fundamental fairness.
This is his narrative.
All right.
You were
Okay.
mean to me.
I'm
Idiot.
being held to.
This is his narrative.
Court's orders. I'm asking that the defense be held to that too. This is
You
something.
haven't
we
been
litigated
honest.
in
Haven't abided by
public
yourself.
hearing.
You've
We spent time
introduced
on
new-
it.
You know, I am
What do
going
you
to interrupt you. And
Uh-oh.
I'm going to let you talk again.
Oh,
But
no.
I was talking yesterday about the Constitution of the United States, and how the Supreme Court has interpreted it for 50 years.
Oh.
That's not what we're talking about here today.
So this is a notice issue to the state. We have not been provided proper notice of this. And clearly, if the shoe were on the other foot and we tried something like this,
You did.
there would be quite a kerfuffle about that. So
Wow, what
that's
chutzpah.
one point.
What chutzpah.
This is.
He
as I
just
said
keeps
earlier,
going.
It's beyond his even his
Why does the
preliminary
judge let him even
report.
argue?
He's
Just
just
let
adding
him
new
upset.
things
We're
at
done.
the last minute like this. And this is not prompted by new drone footage or anything.
Yes,
like
it
that. There's
was.
no mention of drone footage in this report. So to fall behind the excuse of, well, other new evidence has come forward, it doesn't change the fact that this
This
is an
isn't new
expert.
evidence.
There are notice requirements for experts.
No.
There has been no notice of this issue. We've already litigated this, and now the defense is trying to expand it in direct violation of the court's order. One moment, Your Honor.
Yeah, shut up, Binger. Stop talking.
We need a
That's the-
meme where the
Stop
judge
trying
is
to
the
make things
dad.
happen.
Point out that
The judge is the dad,
I think
Binger's
it's
the kid, the Are You
141
Winning Son?
Is a supplemental report that apparently Mr. Black prepared on October 24th, according to the date. We just got it yesterday. So again, another example of late notice
How
here.
many times does he let him argue? the
I
same
understand
motion?
that the court wants to hear, or wants the jury to hear, the
The truth.
timing from the beginning of whenever we start to the end, whenever we draw that line. I understand that.
Okay.
There are other ways for us to do that, of course. We can take other videos. They all have timestamps on them.
Then why not do it
expert
this
is
way?
not needed for that. I don't
It's
think
composite.
we're going to need that time frame down to the hundredths of a second. I think even tenths of a
we do.
second, even 1 second is probably close enough for the jury to understand that this
Nope.
is not something that took days or hours. It was a matter of minutes. So I think they can already get that point.
Then
without
what's the
this
problem with him
expert's
testifying?
testimony. The
And there's zero prejudice to you.
one specific item of prejudice that I do want to bring to the court's attention
Mm-hmm.
is in Exhibit 142. As I pointed out earlier, there are characterizations here.
Well, I agree with you there. The doctors, I assume he's using it for to pinpoint
Timestamp.
particular events, and I agree with you. He's not going to be permitted to do that.
So I want to be, again, I just want to make sure we're all on the same page and that I'm understanding things clearly from the
Because
court.
you rarely do.
There are, for example, observation number 7 on 142 has a characterization of Mr.
Yeah, you're right.
Rosenbaum's behavior.
Replace
That
it
will
with a
not be allowed.
number.
He's going to have to
21.2.
find some way to express that that
Not using the
is
word
not conclusory.
change in elevation.
And I'm going to try to let you do it in a prudent way, and if there's an objection, I'll deal with it.
Okay. So
But yeah, I do think his objection is well stated, that there's some conclusory language in there, which.
Yeah, and Binger knows about conclusory language, militia
they're
man.
queued up. I can refer
This is
to.
why they should have
if he
objected to the
objects to that, I
titles
can
of all
just
their
refer to it
videos.
as 7.
Exactly.
That would seem to be unobjectionable.
Rules
I
for
think
thee, but not for me.
these are things
No,
where
no,
a person's gonna
Binger knows the games that he
show the
plays,
jury
and he's
that
accusing others
item,
of doing
that
that.
moment in time.
Exactly.
They can see it on the screen. Then we don't need
Projection.
witnesses to tell us what we're seeing. That
Well,
that should be
I'm
easy.
not, I can't anticipate what he might ask or what your objection might be, so I'm not going to try to.
Especially
I would
because your
also
objections are
continue by
ludicrous.
objecting to observations 15. 15,
As you mean to the description of the event that he gives?
yes.
Yeah, I think any of his descriptions are going to have to be
Neutralized.
non-conclusory on his part. Okay, perhaps just to point to the particular moment in time and say this is at such and such. an
Seems
hour.
like Binger could have dealt with this prior to the hearing.
I want to raise for.
No, because you can object when it happens, because maybe